This employment law video is on social media. Social media is a great marketing tool for organisations. Used in the right way, it can help develop the brand, promote products or services, and generate custom. However, inappropriate posts by employees can have a huge effect on the reputation of the business. Social media policy. Having a clear social media policy, which is communicated to the workforce and regularly reviewed, helps ensure that employees are aware of the parameters of social media and what is prohibited. A social media policy should, for example, state that it covers all forms of social media, such as Twitter, LinkedIn, Facebook and Instagram, as well as other social media platforms too. It should state that it covers business as well as personal use, when that personal use could affect the business. It should state prohibited uses for social media, such as making discriminatory, defamatory or derogatory comments about the business, staff or third parties. It should provide details of the monitoring of the employer's IT systems and the social media activities. And finally, it should also state the consequences of breaching the social media policy, and that breaching any part of the social media policy could result in disciplinary action, which might lead to dismissal. Training. It's important to train employees on how to use social media to promote the business. It's important that there's consistency, and managers need to be trained on what to publish and how style too. It may be sensible to ensure that junior employees obtain consent from managers before posting about the business. Disciplinary action. Employees may be dismissed fairly for conduct inside or outside work, which could include posting inappropriate comments on social media. For conduct outside work, the key thing is whether the employee's actions affect the employment relationship or the employee's ability to do their job, or there is or could be damage to the reputation of the business. In determining whether a dismissal is fair, the following factors, where relevant, should be taken into account. The nature of the comments, whether the employee was aware of the social media policy and whether the policy was clear, whether the posting is likely to affect the employment relationship or the employee's ability to perform their role, whether there is damage to reputation or potential damage to reputation, how many people have viewed the post or are likely to view the post, the employee's seniority within the organisation, whether there's been a reasonable investigation, and the employee's disciplinary record, length of service and any other mitigating circumstances. Networking sites and client connections. Messaging or posting the employer's clients on networking sites after the employment has ended could potentially breach non-solicitation restrictions. Some employment contracts specifically require employees to delete connections which are clients of the employer when the employees leave. That's my video on social media. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, do visit my website. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.